Hello, everybody. Welcome to today's webinar. My name is Liz Gallagher, and I'm a paralegal at Lyles Parker. Today's webinar is entitled COVID-19 Vaccination Mandates. Today's presenter is Lyles Parker partner Jennifer Papapaniotou. And without further ado, I will pass it over to Ms. Papapaniotou.
Hi, Liz. Thank you. Hi, everybody. Welcome back to 2022, our first webinar of the new year. I hope everybody is staying safe and enjoying return to work this week. I know I am. We are going, I know there's been some previous presentations on the various vaccination mandates, but given the sort of legally dynamic situation with these, TAC and allowed us to do this presentation to sort of give everybody the latest scoop on what the rules, where they stand legally, what they require. Just if I haven't, I know I've done a number of webinars, but just for those who don't know who I am, my name's Jennifer Papapaniotou. I am a partner with Lyles Parker. I'm located in Houston, Texas. So I'm licensed here in the state of Texas. I've been a healthcare attorney for too many years to count, over 20. And I primarily work in compliance and regulatory areas for healthcare providers, do a lot of work with home health and hospice. I do a lot of mergers and acquisitions work for home health and hospice, contracts, investigations, you name it. I've kind of adopted I'm a jack of all trades when it comes to healthcare lawyers, as long as you don't ask me to litigate anything. So let's spend the next hour or so talking about these vaccination mandates. I'll try to give you the skinny on what's going on most recently and summarize the relevant rules for you. So Liz, let's go to the next page. Standard disclaimer, this is an outline only for general information. I'm not giving anybody legal advice. If you need legal advice, please contact your healthcare attorney. Just the standard disclaimer there. Let's go to the next slide, please. All right, so this is a brief summary of what I would like to cover today. I'm going to give you some background on the sources of the various vaccine mandates, their legal status as of today, with the understanding that these change, if not every day, very frequently, with the cases that are pending that involve these various standards. I'm sure you've all been following the news on these various vaccine mandates, and again, it's a very dynamic environment right now. And just to add to that confusion, there are a lot of overlapping regulations that it's very confusing what applies to you in any particular given time, depending on your particular provider type and how many employees you have, and so many other factors. I'm going to try to sort that out for you to, you know, as much as I can for a general audience that's in the home care and hospice business. I'm going to try to give you the current status of each of these various regulations and summarize, and I stress summarize because these are large rules with lots of details. I'm going to try to give you the highlights of them. But I'm going to cut to the end of my presentation and give you the bottom line, where do we stand today summary right off the bat. I'm going to start with the Cms Vaccine Mandate, which we're going to talk about in detail later on, who it applies to, what it requires, et cetera. But I'm just going to say as a blanket statement that as of today, the Cms Vaccine Mandate is enjoined in 25 states, including Texas. So for today, the Cms Vaccine Mandate does not apply to us in Texas right now. The U.S. Supreme Court is going to hear the appeal of that injunction this Friday. We would expect that the Supremes will render a decision fairly quickly. I don't know if it'll be next week, but I suspect it probably will. And for Texas, that means that while we don't have to comply with the Cms vaccine mandate, we do need to worry about the Osha vaccine mandate if your particular healthcare provider organization has enough employees to fall under that rule. So let's talk about that. If you have more than 100 employees, then you do need to worry about the Osha vaccine mandate today, because It is not subject to an injunction right now, and it is technically legally enforceable, although Osha has adjusted all its compliance dates because it was subject to an injunction for a while. Right now, the appeal of the Osha vaccine mandate injunction is pending at the Supreme Court as well, and they are going to hear both the Cms vaccine mandate and the Osha vaccine mandate injunction requests for appeal on Friday together. And we expect they will issue decisions on both of those together. Again, like I said, maybe next week if we're lucky. For the time being, Osha has said it won't enforce its vaccine mandate, which is a little different than CMS's, until at the earliest next Monday, the 10th of January, and it won't enforce the testing option in its rule until February 9th of 2022. So stay tuned. We're going to cover all of this in the presentation. It's a lot to cover in an hour. I'm going to have to, give some highlights here and some highlights there. I'm going to try to move through this fairly quickly, but that's the short version of where we stand today. Now let's dig into the details. Let's go to the next slide. All right, so I'm only focused today on vaccine mandates. It would be impossible to cover, every relevant order, reg, or whatnot, both at the federal and state level in a single hour presentation. So I'm focused only on federal mandates that involve some aspect requiring vaccination. The first two are two presidential executive orders, 14042, which was a vaccine mandate. And it was, we'll dig into what it included in a minute, but basically it required federal contracts to include clauses that required vaccination of both the contractors and their subcontractors. It was issued by the Biden administration in September, and shortly thereafter, it was enjoined by numerous courts. There were legal challenges galore. And the Office of OMB has paused enforcement in all 50 states and the outlying areas as a result of the litigation that's going on. So for right now, there is no mandatory vaccination executive order in place for federal contractors, while that litigation sort of winds through the court system. The second executive order was 14043. It was applied to federal employees. And interestingly enough, there were legal challenges to it, but they did not result in injunctions. And this particular executive order, the compliance deadline for vaccination was November 22nd of last year for existing and new employees. And that date stuck. And while there are exceptions permitted under this particular executive order for religious and medical reasons, the government had, as you might imagine, many requests for exceptions. They've been, while you have a pending exception request, they can't enforce the order against you. So we say there was a November 22nd, 2021 compliance date, but for those who have requested exceptions, those have to be processed, and there's, as you might imagine, a timeline associated with all that. So agencies were given until this month to complete their enforcement actions, and I don't know that they're going to process all exception requests in that time period, but for the most part, this particular executive order has been implemented, and it is currently in effect. Let's go to the next slide, please. Those don't really impact this audience so much because there are other rules we have to worry about. The only one that might affect us would be the federal contractor one, but for the most part, it isn't relevant to most of the folks who are part of this webinar today. I wouldn't say that it would never apply, but for the most part, it's not one we have to worry about too much. We do, I want to briefly touch on the earlier OSHA COVID-19 healthcare emergency temporary standard. It's sort of the next, not that it did not include a vaccine mandate, but it did touch on vaccination. And it's important in the larger conversation about what's been going on with the subsequent OSHA ETS. So I'm going to give you a brief rundown on the June OSHA COVID-19 healthcare ETS. Way back in January, there was an executive order, 13999, that instructed federal agencies, including OSHA, to consider whether any emergency temporary standards on COVID-19 were necessary. This was early on in the Biden administration, and they sort of wanted to spur the agencies to start looking at implementing something more formal regarding COVID and what we would expect of our workplaces. OSHA responded with an emergency temporary standard for healthcare settings, and it wasn't 100% of healthcare settings, but it was most. That was published in June of 2021, and an emergency temporary standard is kind of a unique animal that is not commonly used, frankly. But by their sort of the statutory provisions that allow it to happen, these ETSs are normally a temporary measure in place for up to 6 months while the agency that issues the ETS writes a final rule. And then they have to meet certain conditions for when they can issue an ETS, and the COVID pandemic and the national healthcare emergency meets those conditions. So when this was put out, it was only ever intended to be in place for 6 months, and then the agency would issue a final rule. Well, as you all know now, over the summer and into the fall, it was apparent that there was going to be a subsequent rulemaking, and the only question was who would it apply to and how comprehensive would it be. And we now know what we ended up with were the OSHA vaccine mandate reg that was published in November, which is much broader than the healthcare ETS, applies to many more industries, and includes many more requirements than the original healthcare ETS did. And we ended up with CMS's vaccine mandate that specifically addressed healthcare providers and is considerably more restrictive than this June 2021 OSHA ETS. So it's not surprising that OSHA allowed the June 2021 healthcare ETS to expire on December 21st, 2021. And the only portion of that rule that has been retained are some of the record-keeping provisions. So you'll recall in that rule, you're required to keep a COVID log, people who, your employees who took positive, and you're required to give access to certain of those records, like your COVID log, redacted, names removed, things like that, to all of your employees, and you're required to report certain things to OSHA, like hospitalizations and employee deaths from COVID. Those have been retained, and if you have more than 10 employees, you still have to comply with those requirements. But let's go to the next slide. This just summarizes what's left of this original June OSHA healthcare ETS. For those who, you should already be familiar with this because you already had to implement it. This is the portion that remains now that the healthcare ETS was allowed to expire. OSHA has put out some, specific guidance on this at the end of December. They've clarified and reinforced what the status of this particular ETS is. So I think for the most part, this one is pretty much settled for us. Let's go to the next slide. So the really important, and I'm going to start with the OSHA COVID-19 vaccination and testing ETS and talk about the CMS vaccine mandate next. I debated whether to cover CMS first and OSHA second, and because the OSHA rule is so much, it's frankly, it has a lot more requirements because it's what I would call a soft vaccination reg, meaning it gave employers with more than 100 employees options. You could either choose to implement a 100% vaccination requirement, or you could do a hybrid model where you could do vaccination on a voluntary basis, but for those who did not choose to be vaccinated, you would have to implement a testing option. So you've got an either or, and we're going to cover that in a lot of detail. But as of today, the OVID COVID-19 vaccination and testing ETS was published on November 4th, 2021. It's based on existing Occupational Safety and Health Act authority, specifically the General Duty Clause. And for most healthcare settings were exempt and instead were subject to the OSHA COVID-19 healthcare ETS until it was allowed to expire, which is why we're talking about this standard. There's been a lot of confusion about whether this particular rule is going to apply to healthcare providers, and if so, how. We're going to cover that later on in this presentation. I'm going to tell you about this rule first, and then we'll discuss whether or not it applies in your particular employer setting. But let's just cover what it is first. Under the OSHA Act, like I said, this is an ETS, just like the June one was. So it serves as a proposed rule, and it generally is allowed to stay in place for up to 6 months. Comments on this proposed rule are due January 19th, and importantly to everyone here, while this was enjoined nationwide by the Fifth Circuit in early November, that injunction was dissolved in a separate court action being heard in the Sixth Circuit on December 17th. So this particular rule right now is not enjoined. It has, of course, the injunction case has been appealed to the Supreme Court. It's set for oral argument on January 7th, this coming Friday. And let's go to the next slide. OSHA has said in mid-December that it will exercise enforcement discretion with respect to the compliance dates for this ETS. They had to reset those because of the injunctions. They've set compliance dates of January 10th for the employer to have decided on which path it is going to take, whether it will enforce 100% vaccination or it will do vaccination plus testing, which is one of the options. So they expect employers to have all of the pieces in place by January 10th. Given that the Supreme Court is going to hear this case on the 7th, I don't know if we'll have a decision by the 10th. This is going to be an interesting one to watch, but for purposes of the conversation today, we're going to say OSHA has said they will begin requiring compliance as of January 10th. As long as you're exercising reasonable good faith efforts to come into compliance with the standard, you shouldn't have compliance problems, but these are the dates we've been given as of today. It's currently somewhat unclear if OSHA is actually going to enforce this standard against healthcare employers starting January 10th. I think given the Cms Vaccine Mandate and its somewhat different legal status right now, and the fact that everything's being heard by the Supreme Court at one time on the 7th, we need to just keep our ears open and stay tuned to see what OSHA says about healthcare employers. Since the vaccination and testing provisions of that June 2021 OSHA healthcare ETS has expired, OSHA could require healthcare employers with greater than 100 employees to comply with this rule. But again, OSHA sort of played its cards close, and while technically legally they might be able to do that, they haven't really come out with a clear policy about whether they will or not. So let's go to the next slide. All right, we're going to flip over to the Cms Vaccine Mandate and just give you sort of what it is, what it stems from, and what its status is. But let's be very clear. It is not an emergency temporary standard like the OSHA standard. It is an interim final rule, which is similar, but not really the same thing. It's an interim final rule with comment period. It was published the same day as the OSHA reg. Don't kid yourself for a second. They definitely coordinated on this. It is based on authority granted to the Centers for Medicare and Medicaid Services under the Social Security Act. I've highlighted the sections there. It's important for the legal challenges. Initially, when this rule was published, 10 states filed in Missouri federal court, and they were granted an injunction that applied to those 10 states. A separate series of appeals or cases were filed in Louisiana federal court, and the Louisiana federal court not only issued an injunction, but stated it would be national, which was an unusual move actually by the Louisiana court. Appeals were filed to the Fifth Circuit down in New Orleans, which covers the state of Texas as well, and there was a separate case pending. The state of Texas chose to separately challenge this rule in Texas Federal District Court. So all of these are sort of pending at the same time. The Fifth Circuit ended up ruling on December 15th that the injunction would be upheld, but it would not be a national injunction. They felt that the Louisiana District Court exceeded its authority and could not craft a national injunction based on the case that had been filed in that court. So the Fifth Circuit pared the injunction back to cover only the 14 states that were part of that Louisiana case. The Missouri injunction stayed in place. And the next day, the Texas Federal District Court that was hearing Texas's challenge to this rule issued its injunction. So as of today, the Cms Vaccine Mandate rule is enjoined in half of the U.S. states, 25, including the state of Texas. Let's go to the next slide, please. So, as I said earlier, like the Osha vaccination rule, this has these injunctions have been appealed by the government to the U.S. Supreme Court, and oral argument is set for this Friday. It will be heard with the Osha vaccine mandate oral argument. So they're going to consider these two cases together. They have slightly different legal theories for their appeals. Obviously, there is no injunction on the Osha rule, so the appeal is largely by the petitioner saying we want the injunction, we think you should issue the injunction. And in the CMS vaccine mandate rule, it's the government saying we don't want an injunction and here's the reasons why. So it's kind of both sides of the same argument with slightly different legal theories. So it's going to be very interesting if you're a lawyer. This is, you know, they broadcast these oral arguments if you want to listen. There's I want to say there's a link available on the Supreme Court website, but hopefully we're going to get a decision fairly quickly. CMS did issue some guidance after sort of the initial injunctions came out. They revised that guidance on December 28th and indicated that in those states where there is no injunction, which again, Texas is enjoined, so we don't really necessarily need to worry about this, but in those where there is no injunction, CMS has said they will begin enforcing the rule on January 27th, meaning since that rule includes mandatory vaccination for all healthcare staff or all staff of a healthcare provider, they would expect that first vaccination deadline would be January 27th, and the second one would be 30 days later. So let's go to the next slide. There is still, and I did a presentation with my partner Heidi Kocher back in a year ago, actually. There is still the flexibility for employers to implement their own mandatory vaccination policy. That has been something that's been available. The EEOC came out very early on and said employers could do this, and we did a lengthy presentation on that back in January 2021. I'm not sure, for those of you who went ahead and implemented a mandatory vaccination policy, all of this may be of less, burning interest or concern. Then again, if your policy doesn't include some of the things that are in the new CMS vaccine mandate rule, then you would need to adapt your policy to fit that. If that CMS vaccine mandate for some reason goes away, but the Osha rule stays in place, you'd need to adapt to that, et cetera. You can see where I'm going with this. So if you've had a policy in place this whole time, that's fine, but you need to reevaluate your policy once we have some certainty with regard to both the CMS vaccine mandate rule and the Osha vaccine mandate rule. Let's go to the next slide. All right. Let's dig into some of the details on what the Osha COVID-19 vaccination and testing emergency temporary standard actually requires. The purpose of the rule, Osha has stated, was to establish minimum vaccination verification, face covering, and testing requirements to address the danger of COVID in the workplace. Secondly, they were very expressly looking to preempt state and local laws that interfere with an employer's authority to require vaccination face covering for testing. And that's a very important aspect. The federal government, and this is, part of the appeals, the substantive appeals on whether these regs are constitutional or not is going to deal with a preemption issue, no question. It's not necessarily part of the injunction argument, although there is an element of being able to prove you might be successful on your actual underlying case in order to get an injunction. But this preemption issue, I'm sure, will be part of the substantive legal cases that ultimately are litigated. The effective dates, these revised dates by OSHA are January 10th for all provisions other than testing of unvaccinated employees, and February 9th for the testing provisions if an employer chooses to offer that option. As I said before, it applies to general industry and several other specific areas like shipyards and marine terminals and longshoring and construction and agriculture with 100 or more employees across all work sites. You can't divide your work sites up and say, well, I have an office with 5 here and an office with 95 there. Therefore, I don't have any work site with 100 employees. The rule doesn't apply to me. OSHA has said, nope, you got to add them all together. Healthcare was originally exempted from this rule while the June 2021 OSHA COVID-19 healthcare ETS was in effect. That has now changed. Let's go to the next slide. So because that June ETS has expired, except for the record-keeping provisions, as I said before, technically, OSHA could apply this rule if the CMS rule doesn't take precedence. And because the CMS rule is still somewhat in flux, we kind of have to worry about this. And OSHA really has yet to definitively say whether it's going to enforce this ETS against healthcare employers. And I think they're just waiting to see what the Supreme Court says about the CMS vaccine mandate. I think if the CMS vaccine mandate survives the legal challenges, that OSHA will say its rule is only going to apply if the CMS vaccine mandate rule does not apply to you. And there are healthcare providers that the CMS vaccine mandate does not apply to. Just keep in mind, the CMS mandate is enjoined in Texas right now, but the OSHA, this particular OSHA vaccination and testing ETS is not. So we need to keep our ears open for news on what OSHA decides to do after the Supreme Court hears this injunction case and makes a decision. Your guess is as good as mine. But I would not be surprised to see OSHA say if CMS isn't going to enforce its rule or can't enforce its rules, and they are going to apply the OSHA rule to healthcare. So let's just keep our ears open on that one. Let's go to the next slide. Okay, so who is covered and who is not covered by the OSHA rule? If we assume for purposes of our conversation that this rule applied to you, so you're in the construction industry, what's covered and what's required? If you have more than 100 employees across all your work sites, then the rule would apply. But who is not covered? Well, if you have employees who don't report to a workplace where coworkers or customers are present, they work exclusively from home, or they work exclusively outdoors, then this particular mandate doesn't apply to those employees. Now, if you have employees that fall into multiple categories, meaning some that work exclusively from home and some that come to the office, if you have more than 100 employees total, you still have to implement this rule, even if, let's say, 10% of them never come to the office. You still have to apply this rule to those who do come to the office. The regulation requires every employer to adopt a policy, and you have a choice in which policy you adopt. You either can implement a mandatory written vaccination policy with exceptions for medical and religious exceptions, or the employer can choose to implement a written policy permitting employees to choose between vaccination or providing proof of regular testing and wearing a face covering. So I call this the soft mandate. I've seen that language used in several different places because it does give employers who want to have some flexibility for their staff the option between 100% mandatory vaccination or vaccination plus testing, which gives employees a choice. I think OSHA was probably being a little more pragmatic and understanding that we could have some real workforce and labor issues if they just 100% said mandatory vaccination, no other options. So, OSHA seemed to be reading its audience and was willing to give employers this flexibility. Let's go to the next slide. All right. In addition to having to adopt a policy and make a choice about what kind of vaccination policy you want to implement for your particular company, there are a number of other requirements here. You have to, no matter what, determine the vaccination status of all covered employees. So those that come to the workplace. That requires every employee who chooses vaccination, if you either have 100% vaccination required or you choose the alternative of employees can pick whether they want to be vaccinated or test, then every vaccinated employee has to provide written proof of that vaccination, and there are a list of acceptable forms of proof. If you don't provide that proof, then the employee has to be treated as not fully vaccinated, meaning they would have, if you've adopted the testing option, then they're going to have to participate in that test option. Employers are required to preserve acceptable proof of vaccination and a roster of each employee's vaccination status. And those records have to be maintained as employee medical records. So they have to be segregated from other employment records. And this regulation, of course, and the maintenance of these records is during the entire period the ETS is in effect. Now, I would expect the ETS will ultimately become a final rule. There may be tweaks here and there to it, but because it is essentially a proposed rule, OSHA will finalize it at some point. I think the legal challenges are going to complicate that somewhat and maybe extend the timeline somewhat, but I would expect this rule is going to become final at some point in some form. Let's go to the next slide. So other requirements, and interestingly, on the requirement for employers to determine the vaccination status of their covered employees, if you had been collecting information on vaccination before this rule went into effect, then you do not have to reconfirm each employee's vaccination status so long as the employer collected evidence of vaccination prior to the effective date of the rule and retained records of that proof. This is interesting because OSHA said they will permit any record of vaccination, even if it's not on their current approved list, as long as it was collected before the ETS went into effect. So just, you don't have to go back and reprove your vaccination status. Your employer can rely on whatever was provided previously. You have to be sure, though, that if your employees were vaccinated early on, you collected that information before this ETS went into effect, they still have to be on your vaccination roster, and you did, again, treat their records of vaccination as medical records. Okay, so in addition to adopting a policy and determining the vaccination status of covered employees, employers are required to support vaccination. They have to provide up to 4 hours of paid time off during the workday for each primary vaccination series dose, and that time off has to include travel time. And then they have to provide a reasonable amount of paid sick leave for people to recover from side effects. And there's been some debate about how much time that might be, and whether the employer had to require the employee to use PTO first. The guidance so far has been, yes, employers can require the employee to use their PTO, and if they've exhausted their PTO and they still need time off, you have to give that to them, and something up to about 2 days would be appropriate, an appropriate reasonable amount of paid sick leave. So let's go to the next slide. So if you as an employer choose the second option, that is to make vaccination optional for your employees, then you must implement a testing requirement. And unvaccinated employees must test. And on this slide, I'm going to talk you through the details on what that means. So if an employee reports at least once every 7 days to a workplace where coworkers or customers are present, so for all our home health and hospice home care providers, this would include homes where if your staff only report to customer homes, then you're covered by this, arguably. So if they report at least once a week, then they have to test every 7 days and provide test result documentation. The first question I always get is who pays for the testing? Interestingly enough, the employer is not required to pay for this testing unless there's another law or regulation or a collective bargaining agreement or something that would require the employer to pay for it. And we'll talk about that because OSHA really punted on this, because I suspect that most, if not all, employers are going to end up paying for testing, but we'll get to that. So you got to test once a week if you come to the workplace or a place where coworkers or customers are present, and provide results of that documentation, and remove an employee from the workplace who is unvaccinated, who doesn't turn in their test documentation every week. Interestingly enough, OSHA has said they will accept over-the-counter antigen tests as compliant with this rule, so long as that test is not both self-administered and self-read. So employees can't do the test at home and tell you what the result was. It either has to be observed by a telehealth proctor or the employer. So for example, if you have your unvaccinated employees want to test using an over-the-counter antigen test, then they could all come to the workplace in some secure place that's whatever, and perform the test in front of an employer representative who would then observe the result, and that would comply with this rule. This is a lot more convenient than PCR testing, obviously. I know availability of test supplies has been really difficult for over-the-counter antigen tests the last couple of weeks. We're hoping the supply issue improves over the next month or so. And I know there was some press about that yesterday. I will say in my local community here down in Houston, it's almost impossible to find one of these tests. You can't buy them online. It's been really difficult. But I don't know what the larger supply issue looks like directly from distributors. That's not something I look at on a daily basis, but I understand over-the-counter tests has been tough to get. PCR tests, at least in my local community in Houston, which understandably is a very large city, have been fairly easy to get. Including through the sort of the county, state, city sponsored site. So there may be some flexibility here, and as supplies of over-the-counter antigen tests become more available, I think many employers will choose to go that route, and as it's just so much more convenient and timely. So if an employer has employees that don't report to the workplace or somewhere where coworkers or customers are present every week, say they only come in once a month or something of that nature, then they don't have to test weekly, but they do have to test within the 7 days prior to returning to the workplace and provide results upon their return. So they don't require you to test weekly if you don't come to the office every week, but they do want you to test in the week before you do plan to come to the office. Employers, as I said before, are not required to pay for testing unless another law, regulation, or collective bargaining agreement requires that. However, if you go over and look at the Department of Labor's rules and you look at the guidance under the Fair Labor Standards Act, if you're covered by that law, you probably do have to pay for time spent testing, and you may have to pay for the test. So if ultimately you're going to be subject to this rule, you got to keep your eye on that, what the DOL is saying about paying for testing and giving people time off to do it. I'm not going to dig deeply into that. I'm not a labor lawyer, but based on my research and preparation for this particular presentation, that's what the DOL is saying right now. You are exempt from testing for 90 days. So your employees, your unvaccinated employees, are exempt for testing for 90 days if they've had a positive COVID-19 test or a positive diagnosis by a licensed healthcare provider. That's important because people who have been positive for COVID can stay positive for a long time, even though they're not necessarily contagious. You have to, again, treat testing records like employee medical records and segregate this from other personnel records. Let's go to the next slide. Okay, in addition to all those requirements under the OSHA rule, employees have to report their COVID positive status. If they test positive or they are diagnosed by a healthcare provider, they are supposed to promptly notify their employer. The employer is then supposed to immediately remove them from the workplace, and they are not allowed to return to work until, this is great, had a negative PCR test following a positive rapid antigen test. Basically, that's your false positive antigen test. So they say, okay, you can test yourself to see if you're negative to come back to work, and if you're positive on an over-the-counter test and you have a subsequent negative PCR, then we would consider you safe to come back to work. or when your licensed healthcare provider recommends you can return to work, or, and this is an interesting or, the CDC criteria in isolation guidance for healthcare workers is met. I say that there's isolation guidance specific to healthcare workers, and then there's isolation guidance that applies to everybody else. Obviously, healthcare being a more sensitive environment with patients who may be susceptible and have weakened immune systems, there are slightly different guidelines for healthcare workers. I put up here the very, very briefest summary of what those are today from CDC. And I understand CDC has issued some new isolation guidance for the general public. This is specifically for healthcare workers. And it applies to them whether they're boosted, vaccinated, or unvaccinated. So if we are working, and there's 3 columns here: conventional, contingency, and crisis. Conventional basically means, you know, we've got sufficient workforce and we're not in some kind of crisis situation where we're having a hard time getting staff. Contingency is sort of that middle ground where it's getting tough to find people, and crisis is all hands on deck, things are crazy. Conventional is that they have to isolate for 10 days, or 7 days if they then can produce a negative test, if they're asymptomatic or mildly symptomatic with improving symptoms. The contingency standard, if you're having really, somewhat of a hard time getting staff, is 5 days with or without a negative test, and then obviously they would have mask and take other precautions. In a crisis situation, they actually say no work restriction with prioritization considerations, meaning, how sick are you? I would be very concerned, obviously, about bringing people back into the workplace if they test positive, even with lots and lots of protective measures. But this is CDC's current guidance. I provided a link there if you want to go read it. It's very detailed with lots of discussion about these terms. And if we end up having in the healthcare industry here in Texas having to comply with this rule, and you have more than 100 employees, then I suggest you're going to have to do some deep reading on CDC's guidance about isolation for healthcare workers. Let's go to the next slide. All right, so interestingly enough, under Osha's rule, if an employee tests positive, the employer is not required to provide paid time off for positive cases. Osha will not require it, but it may be required by other laws, regulations, or collective bargaining agreements. You'll remember back in 2020 that the FSDRA, one of the early laws that was passed by Congress back, I want to say it was March or early April of 2020, it included expanded paid sick leave and family leave for COVID. That law and the provisions within it actually expired at the end of December 2020. So right now, there is no expanded paid sick leave and family leave for COVID. It's really up to the employer whether to provide paid time off. Employees can use accrued PTO, and standard Family Medical Leave Act provisions do still apply. So if you're covered by FMLA in your workplace, then you would still have to give your employees who are positive that option, assuming they meet the criteria for FMLA. So interesting, OSHA just decided they're not going to expand beyond what the current requirements are for either for paid time off if an employee is COVID positive. They were going to rely on whatever the Department of Labor's guidance is and whatever the employer's internal PTO policies are. So in addition to all of that, if you choose the second option, which is vaccination is optional under this rule, and you're going to implement testing, anybody who's unvaccinated is required to mask indoors or when in a vehicle with another person for both purposes. And they give some obviously details about what that face covering requirement is, and the exceptions for when they don't have to wear a mask. Interestingly enough, the very last bullet on this page, all employees and customers, visitors must be permitted to wear face coverings, whether required or not, unless doing so would create risk of serious injury or death. This is in response to some pretty prominent news stories about employees in various environments who were told they could not wear masks because it would make people feel uncomfortable. And this was early on in the pandemic. I'm not sure anybody really really faces this kind of issue anymore, but OSHA felt it was important to make it clear that employers could not prohibit employees from wearing masks if the employee wants to. Same thing for customers and visitors, unless there's some health and safety reason why they need to do something different. Let's go to the next slide. All right. In addition to all these other requirements, employers are required to provide information to employees, and they were very specific about what they want the employer to communicate. They have to talk about the requirements of the ETS, the employer's policies and procedures. They have to provide a copy of CDC's key things to know about COVID-19 vaccines. And then they have to talk about the non-discrimination requirements in the reg and the potential criminal penalties for supplying false statements or documentation. This is to address the fake vaccine card concern. So I thought it was very interesting that they are requiring employers to provide their employees with CDC's information about COVID-19 vaccines. I think this was an effort to sort of address concerns that, well, which version of information do you want us providing to people? And OSHA decided, listen, we're just going to pick one version. That's what we're going to require you to communicate. That's not to say you can't provide other information along with it, but you have to provide CDC. Let's go to the next slide. All right. You have to report COVID-19 fatalities and hospitalizations to OSHA. This was in the original June ETS as well for healthcare providers. Not really any different. They've changed the terminology a little bit. If you have a work-related fatality that's associated with COVID, then you have to report that within 8 hours of learning of the fatality. If there's a work-related inpatient hospitalization for COVID, then within 24 hours of learning of that hospitalization, and you follow the usual OSHA reporting instructions about where to do that. I've included that here for your reference. Let's go to the next slide. Like I said, the OSHA rule has a lot more requirements than CMS's. Finally, you have to make records available. Individual vaccine info and test results must be made available to the employee that they pertain to and anyone with written consent by the end of the next business day after a request is made. All employees have to have access to aggregated numbers showing how many fully vaccinated employees there are versus the total number of employees. That has to be provided to any employee or employee rep by the end of the next business day after a request, and obviously to OSHA within 4 business hours of a request. In addition, OSHA can request copies of your written policy and all your other records on this particular implementation of this particular rule. I highly, highly, highly recommend, depending on what happens with the Supreme Court decision after the oral argument this Friday, that you go look at OSHA's COVID-19 vaccination and testing ETS webpage if this rule may potentially apply to you. That is, if you have 100 or more employees. I provided a link, and there are a ton of resource materials on this page, including policy templates and obviously up to the minute info on what OSHA is putting out there about this rule, fact sheets, webinars, and slides explaining the rule, obviously the full text of the regulation. And they are updating this, as things change. So this is sort of my go-to first resource for all things OSHA when I have a question. Okay, let's go to the next slide. We're going to start talking about the CMS mandate. I know I'm getting close to time here, but I will assure you that the CMS mandate is less complicated because it is mandatory vaccination for most Medicare providers. And again, like the OSHA rule, it is one of the stated purposes of this rule is to preempt any state law that might conflict with it. Right now, because there were injunctions issued in 25 that cover 25 states, CMS revised its deadlines for compliance for those states where there is no injunction. As I said before, Texas is covered by one of those injunctions, so we're good here. But for those where it's not, CMS put out guidance to surveyors on December 28th that said that they will enforce the January 27th deadline for employers to have policies and procedures and for all staff to have received their first dose of a two-dose vaccine regimen. And February 28th deadline for all employees to have received their second dose or any one-dose vaccine like the Johnson & Johnson vaccine. Let's go to the next slide. Who does this apply to? Well, basically anybody who's regulated under conditions of participation, conditions of there are three buzzwords, but essentially this is the list. And home health and hospice are on this list, as are home infusion therapy suppliers. So interestingly enough, there is an exception for home and community-based service providers. If you are, however, certified as a home health agency by the Medicare program, or you provide skilled services to the Medicaid program, then this rule is going to apply to you, even if you also provide home and community-based services. So let's go to the next slide. Okay, so who in your agency has to be vaccinated? I'm here to say virtually everyone. It applies to all eligible staff, both current and new, working at a facility, regardless of clinical responsibility or patient contact. I've given you a list here: employees, practitioners, students, trainees, volunteers, contracted staff, anybody who performs duties off-site, so that covers home health, hospice, home infusion, etc., and anybody who regularly enters your workplace. It does not apply to full-time telework staff who never come into contact with any of your other staff, and infrequent one-off vendors, volunteers, and professionals who may come into your workplace. This is repairmen and people like that who you could never enforce this rule against. So when you're deciding who falls into that sort of one-off vendor category, you should consider how frequent they come into your workplace, what kind of services they provide, and their proximity to patients and staff. And of course, you can request that those vendors follow certain protective measures. Let's go to the next slide. The short version is virtually everybody who is on your staff, if they come into your workplace or go into a patient home, is going to have to be vaccinated. So how does CMS define fully vaccinated? It's fully vaccinated generally means it's been 2 weeks since you completed a primary vaccination series. For compliance purposes, CMS has said you have to have a second shot by the deadline they've set. So for those who are subject to this rule right now, that would be February 28th. They aren't going to require it to have been 14 days before that. That's impractical as far as they're concerned. So as long as your staff have completed their second shot, if they do the 2-shot series by February 28th, then CMS would consider you compliant. Again, Texas doesn't have to comply with this yet, but keep your eye on what happens at the Supreme Court. Big question, it was posed to CMS, they responded in FAQ, are boosters required? And the answer is no. However, of course, CMS strongly encourages facilities and staff to review CDC's guidelines and, go get your booster because it's recommended. But for purposes of compliance, you will not be surveyed on it. So boosters are not required at this time. Let's go to the next slide. So, because this does not offer a testing alternative like the OSHA rule does, the exemptions for medical and religious reasons are kind of the meat of, how do employees, they don't really have a choice, but if they have a medical or religious exemption that they apply for, then the employer has to grant that and can then implement accommodations for those specific employees that are granted exceptions. And we're going to talk about that. So the basics for medical exemptions, the employer has to have a process. And if an employee applies for a medical exemption, that documentation has to be signed and dated by a licensed practitioner who is not the same as the employee. They actually wrote that down somewhere. You can't sign your own documentation for a medical exemption. It has to include all the information why COVID-19 vaccine is clinically contraindicated for that particular person, and it has to include a statement by the authenticating practitioner recommending they be exempted. Same sort of process for religious exemptions, except that's entirely, provided by the employee. You have to have a process for permitting staff to request that exemption, and you have to ensure they're documented and evaluated in accordance with applicable federal law and as part of the facility's policies and procedures. So let's go to the next slide. I'm going to talk more about exemptions later on, but I know we're running short on time, so please, if you want to keep listening, I'll keep talking. There's a lot of information here, so I understand though if you have to sign off when we run out of time here, the slides will be available and you can review those at your leisure, and I'm happy to answer questions by email or give me a call. So if someone applies for a medical or religious exemption to CMS's vaccine mandate and that exemption is granted, then the employer has to provide accommodations for the unvaccinated staff member. There are two different legal regimes for those accommodations. We've got the ADA that covers medical exemptions, and we've got the discrimination laws that cover religious exemptions. So, but collectively, you have to come up with accommodations that will work for both. So this is what CMS has said as far as accommodation. You have to have a process for implementing additional precautions. And those can include, they've given examples. These are not mandates, these are just examples. Reassignment to duties that limit exposure. Testing could be an option if you issue an exemption to someone. Physical distancing, masking, these are just suggestions. This is not an exhaustive list by any means, but the goal is to minimize the risk of transmission to at-risk individuals. So if an exemption is granted, you have to kind of custom fit an accommodation to the particular person who's been given that accommodation. Let's go to the next slide. All right, obviously, employers have to keep records. They're very specific records, somewhat similar to what OSHA's rule requires. You have to keep records of vaccination status with details on those vaccinations. Same thing, if someone is boosted, they want the employer to collect that information. And then you've also got to identify every staff person's role, assigned work area, and how they interact with patients if they do. You have to document exemption requests, decisions, and accommodations if they're granted. And if a staff member applies for a delay in vaccination, then you've got to collect the same documentation you would for a medical exemption and identify when they can resume vaccination. And then obviously, if you have employees who exclusively telework, you've got to keep records of who they are and what their work arrangement is so that CMS, when they survey, understands who is not covered by the mandatory vaccination for your particular workplace. Let's go to the next slide. Enforcement will be through survey. For now, it will only be in states where the rule is not enjoined. They will cover this in recertification and complaint surveys. If you're accredited, then your accrediting body will cover this in their either initial or recertification surveys. They will look at 3 requirements when they survey: your process or plan for vaccinating all eligible staff, your plan for providing exemptions and accommodations for those who are exempt, and your plan for tracking and documenting staff vaccination, and then obviously your implementation of those plans. CMS has issued enforcement guidance that basically lays out sort of some guidelines for assessing non-compliant, whether someone's compliant or not. If by the first deadline, a facility is 80% compliant, and if by the second deadline they're 90% compliant, then you're going to basically get a warning. You're going to get notice of non-compliance, but no other enforcement action, and you'll be given time to comply. If after 90 days, meaning 90 days from when CMS issued this guidance, so let's think March, end of March, an agency is still out of compliance in a state where the rule applies now, which of course doesn't include Texas, then if you're still out of compliance after 90 days, then they will take enforcement action. And I suspect this is going to be a fairly aggressive area for CMS. They were pretty on top of issuing the survey guidance and gave pretty explicit guidance to their surveying based on the type of provider. So let's wait and see what happens with Supreme Court rule and whether or not Texas is going to have to implement this quickly. Let's go to the next slide. All right, so I said at the beginning I would cut to the chase about what applies. This is sort of the summary of that. So what applies in Texas today? Well, if under the normal sort of hierarchy that was outlined, if your facility participates in Medicare, Medicaid, and is regulated under CMS's COPs, COCs, or requirements, then the vaccination regulation takes priority and your facility is expected to abide by its requirements. Of course, this rule is enjoined in Texas right now, so we go to the next step. If you're not subject to that rule, then the executive order for federal contractors would apply, or the OSHA COVID-19 healthcare ETS should apply. But of course, the executive order doesn't apply to most agencies, and the OSHA healthcare ETS has expired. So the third sort of level of coverage, if none of the above apply, then employers are subject to the OSHA COVID-19 vaccination and testing ETS if they have more than 100 employees. So today in Texas, actually, we have no vaccination mandate unless you're subject to the OSHA COVID-19 vaccination and testing ETS, meaning you have more than 100 employees. And really, OSHA hasn't said whether they're going to enforce that in healthcare yet. So right now, we're really, really anxiously awaiting what the Supreme Court says, basically. If the Supreme Court lifts the injunction in Texas of the CMS rule, then all Medicare and Medicaid certified agencies will have to comply with the CMS vaccine mandate. I'm hoping we'll have an answer to that by next week. In the meantime, we're going to really listen closely to what OSHA has to say about its rule, and depending on the outcome of the Supreme Court, whether that's going to be applied to healthcare employers or not. So let's go to the next slide. I wanted to spend just a little bit more time talking about exemptions. There have been a lot of questions about the exemption process. This shouldn't necessarily be new because there are certainly disability accommodation has been part of employer responsibilities for many, many years. This is a little bit different simply because it concerns a different area, but every employer is required to have a process to review exemption requests, and this applies under both the OSHA rule and the CMS rule. Both agencies, OSHA and CMS, have basically punted to the recognized authorities for exemptions, and EEOC has guidelines and information they've put out. So really what they're saying is you can grant an exemption for medical purposes based on the recognized contraindications for vaccination per the CDC. I'm not going to get into any debate about who's right or wrong about that. I'm just going to say this is what they've said from a legal perspective. You can grant an exemption for a medical reason if they're on the list of recognized contraindications. For now, this is CDC's list. Severe allergic reactions after a previous dose of the vaccine or a component of the vaccine, those with immediate allergic reaction of any severity to a previous dose, those with known allergy to a component of the vaccine, and any other recognized clinical contraindication on this list that CMS has put out, their summary document for interim clinical considerations. That's a living document, by the way, and it does change over time as we learn more about the vaccines. For example, CDC has recommended a delay in administering vaccine if you've had COVID or received monoclonal antibodies. So again, this requires consultation between the employee and their healthcare practitioner. The healthcare practitioner then has to document why the employee should be medically exempt and explain the medical basis for it. And in order for the employer to grant that exemption, it would need to fall within these recognized contraindications and be supported by that healthcare provider's information about that particular employee. So let's go to the next slide. Accommodations for medical exemptions. You need to consider ADA's guidance on accommodation for disabilities is really what this falls under. Employers are only required to provide reasonable accommodation for employees where making the accommodation does not create an undue burden on the employer. And under the ADA, undue burden means that it would require significant difficulty or expense for the employer. That is a pretty high standard, generally speaking. That's not to say that employers always have to accommodate, but it's a real sort of facts and circumstances analysis. Would it be significantly difficult or expensive for the employer to accommodate that medical exemption? I think it depends on the employee and their work responsibilities. I had a slide a little earlier about potential accommodations. I think those are things every employer is going to have to consider, along with what exactly is this employee's responsibilities, and would it be significant or significantly difficult or expensive for me to provide this accommodation? Again, I can't give you the magic formula for this. I can say that if you have questions or concerns about it, please get with your legal counsel for some guidance. Let's go to the next slide. These are factors that every employer, when they do this kind of analysis, should consider. I don't want to spend a whole lot of time on it, but I will point out, number 3, will the accommodation pose safety risk for the employee or others? It's, you know, the reality of COVID and everybody's, the risks associated with unvaccinated people in a workplace with vaccinated people. You know, you might come to a different conclusion if you're talking about an exemption for an employee who works in the office as opposed to one who sees patients. So there's a lot of information out there about medical exemption and accommodation. I highly recommend you review EEOC's information as well as the information on the link I provided on the previous page from ADA.com. Let's go to the next slide. All right, religious exemptions. This is actually a much hotter topic right now. You have to have a process for employees to request exemption. CMS highly recommends every employer reviews the EEOC's compliance manual on religious discrimination in developing that process and processing exemption requests. There's a lot of information. I reviewed it in preparing this. You have to document every request and the employer's evaluation and decision in any accommodation that's offered. There's so much information on religious exemption, it'd be impossible to cover it all in this particular presentation. As you can see, we're already over time, but I will give you a very brief summary. Exemptions can be granted for sincerely held religious beliefs, practices, or observances. And per the EEOC, the definition of religion is very broad and protects beliefs, observances, and practices with which the employer may be unfamiliar. And EEOC goes into it saying that employers should ordinarily assume that an employee's request for religious accommodation is based on a sincerely held religious belief. So we're going to start by assuming that every request for religious accommodation is legitimate. EEOC then says that social, political, or economic philosophies, as well as mere personal preference, are not religious beliefs protected by Title VII. So with that in mind, this gets even more thorny and complicated. Let's go to the next slide. If there's an upside to this, it is that employers can have a conversation with their employee about a religious exemption request. While you should assume that a religious belief, practice, or observance is legitimate and sincerely held, you can certainly ask questions if there is objective evidence otherwise. So again, I don't want to dig in, and I'm not going to go through some scenarios because I think this is just way too complicated for that, but employers can ask questions. They can request information from the employee describing his or her beliefs and practices, including information regarding when the employee embraced the belief, as well as when, where, and how the employee has adhered to the belief, observance, or practice. Again, you should have some objective evidence before you go down that road, but it's a little fuzzy exactly how much evidence or this is intended to be a conversation, and it isn't intended to be a witch hunt or punitive or anything like that. But the employer does have the right to ask questions if they have some objective reason to. When considering sincerity, and really sincerity ends up being the big question here, is how sincerely is the employee embracing their religious belief, practice, or observance? It can't just be a matter of convenience. They don't have to be vaccinated. Factors that might undermine an employee credibility include these that I've listed. Has the employee behaved in a manner markedly inconsistent with the professed belief? Is the timing of it suspect? And whether the employer has reason to believe the accommodation is not sought for religious reasons. There's some examples and things in the EEOC's guidance that I highly recommend you review if you've not been down this road before, or if you need some guidance on how to go through this process. I provided a link to that on one of the previous slides. Let's go to the next slide. So if you end up granting a religious exemption, then the accommodation, whether you have to accommodate that religious exemption, and again, just because you grant an exemption doesn't mean that you can provide reasonable accommodation. So an employee may qualify for an exemption on a medical basis or religious basis, but you then have to determine whether you can provide reasonable accommodation. As I've said, for medical and disability related accommodation, it's that it has to be a significant cost to the employer or significant burden. For religious exemptions, it's completely different. And an employer only has to consider whether there would be more than a de minimis cost or burden in deciding whether it can accommodate a religious exemption, which is a much lower standard. So employers really end up accommodating much fewer religious exemptions than they do medical exemptions. It's a lower standard, and the employer, again, you may end up accommodating fewer religious exemptions than you do medical exemptions simply because the legal standard is different. It's really, again, important, and these are individualized determinations of what is a reasonable accommodation and what is an undue burden, depending on the kind of exemption that is being considered. Again, I talked about CMS's possible options for accommodation, but you have to go through the undue burden analysis before you even decide whether you're going to provide that accommodation. And then, that has to be looked at holistically. What kind of accommodation is being, it makes sense. Let's go to the next slide. Okay, again, things to consider when evaluating a religious accommodation request or exemption and accommodation request. What is the employee's limitation? What is the employee's job? And will an accommodation pose safety risks for that employee or for others? And what about the safety of patients? So I'm not going to say it's simple by any stretch. I think the exemption process itself and the decisions about accommodation are very, very complicated. Again, if you have questions or you need help through that process, please reach out to your counsel and review those resources that we provided throughout the presentation. Let's go to the next slide. That's all my words for now. I will be anxiously watching and waiting for the Supreme Court to rule after the oral argument on Friday. I think we'll know a lot more next week about both the CMS vaccine mandate and the Osha vaccine mandate. And we will communicate that through our website and our newsletters to clients of our firm. Please feel free to reach out to me. My number's there, and I just realized my phone number on this slide is not correct. Reach out to me by email, or you can call our general number, which is on our website, lylesparker.com. I'm happy to answer questions if anybody has one.
Hey, Jennifer, thank you so much for that presentation. I have some questions that were submitted during the last hour, so I don't know if you've already addressed them, but I can read them and
I haven't seen them, so.
Okay. For the CMS mandate rule, are we still able to accept exemptions for vaccine, either medical or religious? I think you addressed that one.
Yes, absolutely.
Okay. Can you help draft an appropriate vaccination policy for a medical practice or agency?
We have done that for clients, so reach out to me by email and we're happy to talk about that. Keep in mind, the CMS vaccine mandate does not apply to physician offices.
Okay. Let's see. Is there any guidance on whether or not the COVID testing can be the home testing kit? I think you addressed that as well.
In the Osha rule, they expressly, and in their guidance, FAQs and such, they talk about the rapid antigen test that you can buy over the counter. Again, it can't be both self-administered and self-read, so it has to be done in the presence of either a healthcare proctor or the employer. But yes, they can be used.
Okay. Someone wrote, I just read an article on USA Today stating the Supreme Court will allow states to determine a vaccine mandate. I think that was just a statement.
I'm not familiar with the article, but I will go look for it.
Okay, let's see. Is it 100 or more at each site, or total for company?
Total for company.
They provided, I'm going to add to that previous comment. For example, we have branches in Indiana and Illinois. but not 100 employees at our Texas office. So that's across states.
It's kind of a complicated analysis and not one I'm prepared to answer without knowing more about your particular business. I would say if you have multiple companies set up, meaning you've got a company in Texas and a company in Indiana and a company in another state, and they all have separate payroll reporting and separate systems, then you may be able to slice and dice that. But again, without knowing more about your organization, I recommend you talk with your particular counsel, or you can reach out to us. We can try to help you answer that question. Almost more a question for an employment lawyer, but I'm happy to field those questions and get you some resources.
Okay. Someone wrote, do hospice volunteers have to be vaccinated?
Yes, if they are, yes, the answer is yes.
Okay. Let's see. Whew, lots of questions today.
I should say, qualify that. Under CMS's mandate, yes, hospice volunteers have to be vaccinated.
Okay. Someone wrote, just to clarify, since the June ETS expired, we are no longer required to continue to pay employees that are out due to COVID-19, correct?
That is correct. They still have to be permitted to take their PTO, and it's up to the employer to decide whether to give them more paid time off. You do also have to follow whatever other, if you have collective bargaining or something like contractual agreements with people, you have to follow those.
Okay. We have quite a few more questions. Do you want me to continue?
I'm happy to stay on if people want to listen.
Okay. The next question is, what about proof of antibodies for vaccine exemption?
That isn't acceptable under any of the standards. The only exception that they've put out there is they're under the CMS rule. You can delay vaccination for up to 90 days after COVID infection or antibody therapy. Meaning if you've had monoclonal antibody therapy because you had COVID, then there's a period of time where you can't be vaccinated, and CMS will give up to 90 days in that instance.
Okay. And how many religious or medical exemptions can be granted per agency?
There's no particular limit. You just better have your documentation in order.
Okay.
And you have to be able to provide reasonable accommodation. And so just keep that in mind.
Does CMS also restrict self-administration, self-reading of OTC tests?
There is no testing option for CMS's vaccine mandate. If you grant an exemption and one of your accommodations is that the employee will test, my understanding, and this is based on my reading, is that CMS would largely be okay with what Osha has recommended as far as its testing regime.
Okay. Meaning
weekly testing, yes, over the counter, as long as it's not self-administered and self-read.
Okay. Next question. What if the physician office is part of a healthcare system of more than 100 employees?
I'm going to say you need to, and the question there is multi-layered, right? Physician offices in and of themselves are not subject to the CMS vaccine mandate because they aren't certified providers. They fall under a different category. The question then becomes, well, does the OSHA standard apply? And I think that's a difficult question to answer without understanding more about the structure of the business, right? My suggestion would be to go to the health system and ask them that question. They've undoubtedly been considering whether and what may apply in that particular instance.
All right.
And of course, I'm happy to talk offline about it.
Next question. I am a PHC agency with contract only with Medicaid's PHC PAS program, not Medicare certified, and have less than 99 employees. Am I required to do this vaccine mandate?
So right now, Texas isn't required to do anything for CMS's vaccine mandate. There's language in the CMS regulation that expressly exempts home and community-based service providers as long as they are not Medicare or Medicaid certified. It sounds like you may fall into that category. I would suggest you should verify that with your healthcare counsel, who can talk a little bit more specifically about your situation. But it sounds like you may fall into that narrow category that neither of the rules apply to.
Okay, looks like this might be the last question. If the home office staff, support staff, do not have contact with clinicians, i.e. clinicians come in the office and have direct access to materials without being near office staff area, can the office staff be exempt from vaccination in CMS mandate?
No. Everybody, literally everybody who comes to the workplace, that includes the home office, that includes any branch location, that includes patient homes, etc., has to be vaccinated under CMS's rule. Again, CMS rule is enjoined in Texas right now, and we'll know more about whether that's going to be changed once the Supreme Court hears the case on Friday.
Okay. The last question is somebody asking for you to pronounce your last name again.
Okay, here it is. Papa Pana Yosu. The G sounds like a Y, so Papa Pana Yosu.
Okay. Well, that concludes the questions. So.
Okay. Well, thank you everybody for listening. I appreciate it, and keep your eyes on the news. I know I will, and I'm sure we'll be happy to talk to anybody offline who may have questions. My email is on this last slide. I apologize, the phone number is not right, but you're welcome to go to our website and call our general number, and they can put you in contact with me. Thank you, everybody.